Good morning, everyone. Welcome to the final round of the 50th annual Wagner Competition. Throughout the weekend, we've been joined by talented competitors from all over the country to showcase their hard work, dedication, and advocacy skills in oral arguments. Of course, we could not have hosted these spectacular teams without lots of help and support.
So we'd like to first extend our thanks to the NYLS Moot Court Association members who have worked so hard to help us facilitate this competition throughout the weekend.
We'd also like to thank our wonderful Wagner committee who have been essential in preparing for this competition since winter break. And we'd also like to thank our vice chair, Angela Cefarello, for all she's done this weekend.
Angela, if you could come up here, we have a little gift for you. We also want to say thank you to our Moot Court Association Chair, John Anthony West, who will also serve as the bailiff in this final round. We are a student-run organization, and John is truly the blueprint of what it means to be an effective leader. He continues to dedicate so much to our association, has been tremendously helpful in preparing for today's competition. And we also got him flowers.
Next, a special thanks to Catherine Grabowski and Anna Greenberg, our excellent Wagner authors. I'm sorry. And Seth Wynn, our executive research editor. This writing team worked on this fact pattern for nearly 6 months. We are so proud to see your creativity and knowledge come to life. Also, we would like to give a thank you, to Andrea Johnson and Scott DeLuca, who advised the writing team on the fact pattern, and our executive editors, Brandon Amato, Andre Guafaro, Owen Minot, and Cassidy Lang.
So we would like to give a very special thank you to Susan Torado in the back over there. Susan has dedicated such significant time and support to us to plan this whole weekend. You came and joined us last night. That was all Susan at the Wagner Ball. And you keep the train running, and we greatly appreciate you. And we have some flowers for you as well, so if you can come down here.
To our faculty advisor, Professor Ann Schofield Baker. Professor Baker spent nearly 25 years as a partner in AM Law top 50 firms in New York, where she focused on intellectual and corporate commercial litigation. She has also been teaching at New York Law School for over 15 years. In addition to serving as a faculty advisor for the Moot Court Association, she teaches trial advocacy, depositional skills intensive, and trial advocacy intensive. Professor Baker teaches us so much, and we truly could not have facilitated this competition without her help and support. We also have flowers for Professor Baker.
Now we're actually going to pass the mic.
Excellent. So here we are again at the end of the weekend, which you can tell by my voice, I sound like a frog. And for that, I am truly, truly apologize. But it has been a fantastic weekend. This is one of the most important events that we put on here at New York Law School, and we can't do it without our fantastic Moot Court Association. The students, congratulations to you. This is a big weekend. And, you know, as we were out last night with by the way, thank you for coming out with us. It was very fun. A number of competitors asked me very specifically, how is it that your team has such spirit? How is it that they all clearly come to this? They hang out, they like each other. They really support each other. And I mean, I don't know what the secret sauce is, but you're right that they have it. And I think in part it might be because it is very difficult to get on our court team. We run a competition that is almost now the size of this Wagner competition just to get on moot court. And it's the only way you can get on. You can't grade on. You can't get on by the recommendation of a professor. And I think that sort of putting them through that large scale competition makes them really want to be here when they get on the team. And I think that that really helps them to be a cohesive unit. They help boot each other, which is really great. So anyway, that's, I think, in part an answer to the question about why are they so awesome. That might be the reason, but they also are just. Anyway, I also want to thank the Wagner competitors. This is a lot of work. And I wanted to just give you a particular kudos for joining your moot court association. So I was the hiring partner at many different large law firms in the city. And I always looked for moot court experience, in part because it's collaborative. You have to work with a partner. You learn how to write and you learn oral advocacy skills. So all of those things combined are very attractive to employers. So smart, good for you for doing this and stick with it. I also now just want to thank the Wagner chairs this year, Victoria Glenn and Marissa Andreoni. Fantastic work. I mean, this really is an enormous undertaking, and they have just completed the competition with flying colors. It's run so smoothly, and the fact pattern again. I do just want to thank again Kate Grabowski and Anna Greenberg for their fantastic fact pattern, and Seth Wynn, were just instrumental in putting it together. Well done. It's been fun to watch it all weekend. And our editing team, led by Brandon Amato, graded all of your briefs. That was it. That was a huge job at all of the editors. And John Anthony West is our chair, the heart of our team as well. Fantastic job. Everyone's been running around all weekend. And again, I do want to thank Susan Torado again. Honestly, I say this every year. She hasn't slept since like Friday. So this is a big event for her. We really thank her for everything that she does. And now the last thing I just want to note is we prepare for this competition while we are sending 16 teams out to compete in their own competitions. We had briefs due yesterday. We had teams mooting on Saturday. It's totally nuts. And the fact that they are able to manage their time in that way, I am very impressed. Anyway, and with that, I just want to say it's been a fabulous weekend. I saw many of the rounds. The competition was very fierce. So congratulations to our competitors to making it to the final round. Oh, and lastly, I forgot to thank the 231 practicing attorneys who judged this competition. You will note that there was not a single student who judged a single round. We had a minimum of 3 judges, mostly 4 or 5 judges in every round. We worked very hard to do that. And are very thankful to the judges for donating their time. Anyway, and with that, I am pleased to turn the mic over to Dean Bill LaBiana, who is the Dean of Faculty, the Rita and Joseph Solomon Professor of Wills Trust of Estates, and the co-author of Journal Legal Education. Bill, off to you.
Thank you, Anne. Good morning, everyone. Welcome to New York Law School again. This is, of course, the 50th Wagner competition. So that leads me to just take a moment of your time to make 2 brief, really historical points. One is this month, on the 25th, is the 125th anniversary of the Triangle Shirtwaist Faculty, in which well over 100, almost all young immigrant garments burned alive, because the exits from the floors on which they were working at a building that still stands, it's part of MIT, Washington Square, were locked. The reaction to that tragedy brought about the first real state legislation regulating what we would call workplace safety. At the heart of that effort in the New York State legislature was Robert Wagner, then a member of the state legislature who would, of course, go on to become senator. And as senator from the state of New York, the principal author of the Labor Relations Act, which in the 1930s reshaped and set the form for all labor law at the federal level until our time. That's the first. The second is about what you're doing. Practicing arguing before appellate courts has, in one form or another, been the training of lawyers in all the legal systems descended from English common law for, 700 years. And there's a really important reason for that. Our legal system has always been heavily reliant on the law made by the appellate courts with the aid of the advocates who argue before them. In all the time our legal system has been in existence, I say all of those descended from what began to happen in England in the 13th century, legislatures do make statutes, but their application to the problems people have is what has actually developed the law and made it grow and made it a tool for solving the problems yet to come. The judges, of course, have the power to make those decisions, but they can't do it well unless the advocates who are before them know what they're talking about, have the deep knowledge of what they're talking about, and present it in effective ways. So all of you who are taking part in this competition and competitions like it and moot court activities throughout American legal education are not only training yourselves for whatever part of the profession you're going to enter, but you are in training to make our legal system work better. So like so much of what lawyers do, it's much bigger than us individually. And I thank you for making the enormous effort to become effective advocates and effective contributors to the development of our law.
Thanks, Dean LaPiana. It's always special to have Dean LaPiana speak. He is a historian in addition to his legal training and always brings a tremendous perspective. So it is a great honor for me to be here. I'm Anthony Crowell, the Dean and President at the Law School, and this is such an important moment for us. It's a historic one, 50th anniversary of the annual Robert F. Wagner National Labor and Employment Law Moot Court Competition. And I really appreciated Dean LaPiana's perspectives and referencing the shirtwaist factory fire and that women perished. And I noticed today that we have two teams competing, both comprised of women. And it's a real testament how far we've come and that women's voices are being given full force in the fight for equality and certainly in the context of labor and employment law. So as a school that has 70% women in its entering class, I'm particularly proud of this moment for us and to welcome these competitors. So let's give them a round of applause. I'm also grateful to Professor Ann Baker, who, as I said the other night, brings a tremendous amount of heart and passion and commitment to really building this moot court program at the law school. I think part of that passion and commitment is not only because she is a fierce litigator herself, but also somebody who is a graduate of our school and represents the very best of our institution. And it's always a point of pride for me to have our graduates teach our students, because I don't think there's any better representative of what a New York Law School education can yield. And our graduates, hands down, are just extraordinary. So thank you, Professor Baker, for all you do for this wonderful group and the inspiration you provide and the discipline and the drive. And it's really great. I also want to thank the leadership of this competition. The Wagner co-chairs, Marissa Andreoni and Victoria Glenn, have been wonderful. They bring a great deal of not only commitment, but positivity. They couldn't be more positive in their energy and in their approach and in their inclusivity to making this a competition that's not only well run, but that is fun and that is meaningful. And of course, I want to thank Kate Grabowski and Anna Greenberg for their wonderful work on the fact pattern. And of course, John Anthony West, another Anthony. We've got a lot of Anthonys here today. I mentioned this the other night. We have Anthony Cannataro, one of our high court judges here, the Court of Appeals judge, who's going to be our Chief Justice today. So there's a lot of Anthony action here. A series of the awards will be a Tony Award, I guess, right? There you go. You did come to New York. So, and of course, my gratitude to the entire Moot Court Association. I do, Seth, thank you for your great work for this. I want to make sure you're recognized as well. I am particularly amused that this fact pattern is about Love Island. You think about opportunities to bring pop culture and references into it. And I've been thinking a lot lately that, maybe there's a course on the law of heated rivalry. And it's not the NHL. It should be a sports law kind of theme, or it could be a labor and employment law. I don't know. And so we'll see, maybe. But Love Island, I actually think heated rivalry might be what we have here today, in a very different context, I hope. And we are not talking about hockey. But in all seriousness, it's a great fact pattern because I think it brings to life things that we can not only understand, but have a little bit of fun engaging with. And sometimes reality is stranger than fiction, and sometimes the two get blended a bit. So, and here we are. So with that, I do want to congratulate everyone for this moment. And I think for me, watching this come to life is all about leadership. And one of the most important things that any advocate can be is to ensure that they are a leader who understands the needs of their client, who understands the law, who understands the facts, and who can bring the body of their work in preparation to the fore and ensure that there is more than adequate, there is zealous and committed representation to everything we do. So you all represent the very best of that. Your futures are extraordinary. It's a moment in time when we need the fiercest of advocates for our nation and our world. I couldn't be more proud to be your dean for those of us in the room, for those of you in the room who are students, but also to welcome many others from schools around the country to this moment. So thank you for all being here, and I look forward to the competition.
Thank you, Dean Crowell, and thank you for everything that you do for the Moot Court Association. Hello, everyone. My name is John Anthony West, and I have the pleasure of serving as the chair for the New York Law School Moot Court Association. First, I'd like to thank all of our competitors for making the 50th anniversary of the Robert F. Wagner National Labor and Employment Moot Court Competition such a special occasion, not only for our MCA team, but for MYLS as a whole. This competition is truly a labor of love. It requires so many helping hands to make sure that this weekend is both successful but enjoyable for the 40 teams and over 100 judges that partook in the past 3 days. While this entire weekend is a collective group effort, I would be remiss if I didn't thank a few specific people. First, to our authors, Catherine Grabowski and Anna Greenberg, and our Wagner research editor, Seth Wynn. Thank you for all your work bringing Elia Kadeb's story to life. Without the three of you, there simply would not be a Wagner. Thank you to our editor-in-chief, Brandon Amato, and our executive editors, Andre Guafaro, Owen Minot, and Cassidy Lang. This amazing team juggles grading all of your briefs, editing the fact pattern and the bench brief, and they ensure that this competition meets the lofty expectations that we set for it. To Angelo Cefarello, our fantastic vice chair, thank you so much for all your hard work that you put into this competition, but every competition. She makes sure that our entire team gets where they need to go every competition and was locked with me in the scoring room the entire weekend, making sure things run smoothly. Thank you so much for all your hard work this year. I'd also like to extend a massive thank you to both of our Wagner co-chairs, Victoria Glenn and Marissa Andrioni. They're the heart and soul of this competition. Every piece of paper, every email, every minute detail was thought of and handled by the both of them. They worked and agonized over this competition for countless nights, and I watched them succeed in every single possible metric. I'm incredibly proud to have worked with this duo, and as a token of the MCA's gratitude, I would like you both to accept these flowers. Susan Tirado. What can you say about Susan? Nothing on this team gets done without her say so. She made sure everyone had food to eat, all the judges got where they needed to go and got their CLE credits. She made sure that the Wagner ball had the perfect amount of balloons. Susan, thank you so much for everything. All these competitions come together because of your support. And finally, Ann Schofield Baker, our faculty director. Thank you so much for all the hard work and late nights that you put into this team. Ann Baker is the lifeblood of the Moot Court Association. The lifeblood of this competition and this organization would not be anything without her hard work. Thank you to all of our competitors for their spirited arguments, all the judges this weekend in our final round bench who's not here yet. There is no Wagner without any of you. Good luck to our final round competitors, and thank you, everyone. I would like to now turn over the podium to our writing team for a brief resuscitation of the facts.
Good morning, everyone, and welcome to the final round of the 50th Annual Robert F. Wagner National Labor and Employment Law Moot Court Competition. My name is Anna Greenberg, and I'm one of the co-authors of this year's Wagner Fact Pattern. I am joined here today by my incredible co-author, Kate Grabowski, and our wonderful research editor, Seth Wynn. Before we say anything about the problem itself, there are many people we would like to thank. First, Scott DeLuca and Professor Johnson, thank you for your expertise in labor and employment law and for your generosity in guiding us throughout this process. Your insight helped shape this problem from its earliest stages. Professor Baker, Wagner continues to thrive because of your unwavering support, high standards, and belief in the students who write and compete in this competition. We are so grateful. To Susan Tirado, your behind-the-scenes work makes this entire weekend possible. This competition runs as seamlessly as it does because of you. To John, writing a fact pattern is stressful. You are always our sounding board and there to support us. To our executive board and editing team, every strong fact pattern is the result of thoughtful critique and tireless revision. Thank you for pushing us to make this problem sharper, clearer, and more challenging. To the Wagner co-chairs, Marissa Andrioni and Victoria Glenn, thank you for leading this competition with such professionalism and dedication. And finally, to our competitors, thank you for bringing this record to life. Watching you grapple with these issues has been the most rewarding part of this process. You have exceeded every expectation.
When we began drafting this year's problem, we wanted to design a fact pattern that felt both modern and unsettled, one that reflects the evolving tensions of labor and employment law. This year's case arises out of season 8 of Love Island, a reality television competition where influencer contestants are paid to appear while competing for a grand prize. What begins as a glamorous entertainment setting quickly transforms into a dispute at the intersection of two major federal statutes, the Equal Pay Act and the National Labor Relations Act. At the center of the case is Aliyah Kadeb, a fashion influencer who discovers that her male contestant, Henry Jones, is earning substantially more than she is for the same work. Love Island's compensation policy is mechanical. Every contestant is paid 20% more than their most recent reality television salary, and no other factor is considered. When Kadeb discusses pay with her fellow female contestants, the women engage in a partial work stoppage. The producers respond by firing them. From there, the dispute unfolds along two parallel tracks, one under the Equal Pay Act and one before the National Labor Relations Board. This problem asks competitors to wrestle with three questions. First, what evidentiary showing is required to establish that prior pay was not based on sex discrimination? Second, can prior pay salary alone qualify as a factor other than sex under the Equal Pay Act? And third, did the NLRB exceed its remedial authority under Section 10C of the NLRA by awarding expanded compensatory relief retroactive to the inception of the employer's unlawful policy?
On the Equal Pay Act issues, courts are sharply divided. The Ninth Circuit has categorically barred reliance on prior pay. The Fourth and Seventh Circuits take a textual approach and permit it so long as it is bona fide. The 10th and 11th Circuits allow it only in combination with other legitimate factors. And the Federal Circuit has required an affirmative showing that prior pay itself was not the product of sex discrimination, without clearly defining what that showing entails. The uncertainty is central to this case. If prior pay may reflect historical discrimination, how much must an employer do before relying on it? Is an internal investigation enough? Must there be an adjudicative finding? Or does the burden shift more heavily onto the plaintiff? On the NLRA side, we confront another developing fault line. The board has recently expanded its conception of make-whole relief to include consequential economic harms. But several court of appeals have pushed back, emphasizing that Section 10C only authorizes equitable restoration, not full compensatory damages. We intentionally place these issues in the setting of reality television, an industry driven by marketability, prior contracts, and public perception. This is all to highlight how traditional labor and employment doctrines can operate in modern workplaces.
Writing this fact pattern has been the most challenging and rewarding experience of law school. From early outlines to final edits, this was a collaborative effort rooted in careful research, debate, and revision. Anna and Kate, it has been an amazing journey to get here, and I'm so glad we were able to do it together. I feel like I can speak for myself and the rest of the Moot Court Association in saying that we are all so proud of you. And to everyone here, judges, competitors, faculty, and friends, thank you for making the 50th year of Wagner such a meaningful milestone. We hope you enjoy engaging with this problem as much as we enjoyed creating it. Best of luck to our finalists. Thank you.
It's time to begin the final round.
Yeah.
Yay! So first, we're going to welcome this year's final round bench. First, we have the Honorable Anthony Cannataro, who serves as an Associate Judge of the New York Court of Appeals.
We also have the Honorable Judge Joel H. Slomsky, a senior judge of the U.S. District Court for the Eastern District of Pennsylvania.
Next, we have Andrea Johnson, a professor of law at New York Law School who teaches courses in the areas of contracts, employment discrimination, and civil rights litigation.
We also have joining us R. Scott DeLuca. He has devoted himself to labor and employment law for nearly 25 years and is currently of counsel at Ogletree Deakins. And he is also a senior fellow of the New York Law School MCA and helps our association year round.
And our final judge is Melanie Speight, who serves as special employment counsel in the Labor and Employment Law Department at Proskauer Rose.
I think Angela's now going to bring all our
First case on the calendar this first day of the month of March 2026, Alaya Kadeb versus Love Island LLC.
Morning.
May I proceed?
You may.
Good morning, Chief Justice, Justices, and may it please the court. My name is Tori Vasquez, and I, alongside my co-counsel Carla Rubio, represent Alaya Kadeb, the petitioner in this matter. I will address why this court should reverse the 14th Circuit's decision regarding the EPA claims, while my co-counsel will address why this court should reverse the 14th Circuit's decision regarding the NLRB claim. We respectfully request 1 minute for rebuttal.
You have 1 minute.
Alaya Kadeb is more than just her prior pay. She is the connection with her fans, the face of brands, and an influencer rooted in transparency. When faced with an unfair pay disparity, she spoke out against respondents' unlawful use of her prior pay as the sole factor in determining her compensation, especially when discriminatory sex-based considerations permeated her prior pay. Today, we respectfully request that this court reverse the 14th Circuit's decision for 2 reasons. First, in establishing that prior pay is discriminatory, a legitimate question of fact is enough, where, as here, the emails obtained demonstrate the sex-based considerations in deliberately paying Ms. Kadeb less than her male counterparts during the course of her previous show.
Is there anything more to establishing that prior pay was discriminatory than just showing a difference in the pay rates between people of the opposite sex?
In terms of Love Island, we can look to the pay rates, but then we can also look to the conduct of the employer here, where Love is Deaf, Ms. Kadeb's previous employer, was discriminatory in their pay rates.
So, and I'm speaking about the latter, the former employer upon whom the current salary is based. Does that involve more than showing a disparity in pay rates, or is it simply enough to show that there was a difference in pay rates to say that that was a discriminatory pay rate?
The pay rate difference would be an indicator to an employer that they're violating the first mandate of the Equal Pay Act for equal pay for equal work. And then when looking to the underlying behavior, further bolsters. And in this case, we're at the summary judgment stage where there's a genuine issue of material fact as to how Love is Deaf created a pay structure that resulted in disparity and thus was transferred.
Your client didn't know that her Love is Deaf salary based on gender discrimination, correct? At the time she was working there and got her position with Love Island.
The results of the investigation came afterwards, correct?
And certainly Love Island didn't know that the prior pay was Island responsible for something that neither your client nor they knew.
That's the exact problem of using prior pay in isolation as Love Island did here. Here, Love Island was on notice that they were violating the statutory mandate of the EPA, which requires equal pay for equal work. When we look to the record on this case, when they chose to create a pay policy based on prior pay, they created a $48,000 disparity between Ms. Gadeb and Mr. Henry Jones.
So is your first line position that there should be no prior pay defense available for this kind of claim, more akin to what the Ninth Circuit has done?
No, our position is to adopt the Federal Circuit's holding in Boyer versus United States, which encourages employees to use, when using prior pay, to use other legitimate factors alongside that to avoid this type of discrimination from being imported into future salaries. But if they choose to do so in terms of using it in isolation without any due diligence, then they face jury trials where in this case, summary judgment was inappropriate.
Would you? Okay.
This investigation should not be sufficient to grant summary judgment on Love Island's affirmative defense, because when we look into the record, there are 3 significant facts that should be analyzed. And these facts should be analyzed in favor of the non-moving party, which is here, Ms. Gadeb. Rather, this investigation was found in favor of the light most favorable to the moving party, Love Island. When we look to these 3 significant facts within the record, we can see on page 4 that a former producer came forward when it came to light that this prior pay was the base reason as to how this pay structure was decided. Then we can see that emails were obtained between producers discussing men and women and claiming that the women were not hot enough to be paid as much as the men. Then when looking further onto page 5 of the record, we can see that the 3 highest earners on Love is Death, Ms. Gadeb's previous show, were all out earning her, and she was beneath them as the 4th highest earner on the show.
But it's all based on the prior pay they got from being on other shows, 20% higher. And there, at least in one case, there was an investigation done, and it was found that their practices of the prior show was not discriminatory. Is that a sufficient factor base to lead to an inference as no discrimination by Love Island in this case?
No, Your Honor, because the circumstances surrounding the investigation, as well as looking at all of those facts as a holistic approach to it, when the investigation was paid for and hired by the network that produces Love is Death, then moving forward and finding these comments and jest alongside the text messages that discuss Ms. Gadeb's weight in relation to her pay structure on Love is Death.
So
and saying,
what would you consider to be legitimate reasons for differential in pay between the sexes?
if we look to considering Love Island and the other factors that they could have considered, they could have looked at Ms. Gadeb's social media following, diving in further to her engagement with her followers, how many likes she's receiving, how many video views she's receiving. They brought Ms. Gadeb on because she had significant brand deals with other brands within the influencer space.
I just want to, before we get too far, I just want to get back to the investigation for 1 second. It's obvious to me that you don't think that the result of the investigation should be dispositive of this question at all.
Correct.
But would you at least allow for the possibility that it might be of some value, that it should be given whatever weight a fact finder such as the court here would want to give it? Or are you saying it cannot be considered under any circumstances?
It can be considered for a jury to decide. That is the more appropriate audience here to move forward on this. Summary judgment was inappropriate because allowing this affirmative defense for Love Island to be found when the summary judgment standard mandated by Rule 56 of Federal Rules of Civil Procedure requires these facts.
Would
to be
you
viewed
say
in light
that
most
in
favorable.
opposing the summary judgment motion, you were the opposition on the summary judgment motion, right?
Correct.
Did you raise a legitimate issue of fact for a jury to consider after the introduction of the internal report?
The facts raised here were the legitimate question that we believe summary judgment should not have been granted.
And those are what?
The significant facts are the producer coming forward regarding the love is deaf pay structure and the sex-based considerations and conversations that were had.
Mhm.
The emails where Miss Kadeb was reduced to a hotness scale in comparison to not being paid as much
It's
as
the
the
same
men.
facts that were part of the investigation, essentially.
Yes, and we believe that this is enough to create a genuine issue of material fact. And our standard that we are proposing here, the evidentiary showing required to get forward on a jury trial, is this legitimate question of fact. And it best aligns with what Rule 56 mandates, which is to when, no matter what facts are when the facts are presented, they are supposed to be viewed in the light most favorable to the non-moving party. When a third party investigation here that is hired by and paid for by the network that produces the show, of course they are going to find and reduce these comments to mere jest. But respectfully, Your Honors, reducing Miss Kadeb to a hotness scale is not funny, especially when it is those conversations are directly tied to her pay structure. Producers.
My question is, ours to remove, and this was not the response. This was the prior employer's conduct. Wouldn't it actually be prejudicial for that information to come into the jury because you're attributing it to Island that they didn't know?
No, because under the Federal Circuit's holding in Boyer, Love Island has a way to get around this by considering other legitimate factors with prior pay. We are not shackling Love Island or other employers from never considering prior pay, but they must do so with other legitimate factors to safeguard any discriminatory animus that is brought forth. But when they
other factors other than sex. Here it was prior pay. Why isn't that a factor other than sex?
Because before moving to the affirmative defenses allowed under 2061, we must require employers to consider the promise and requirement of the EPA, which is to pay employees who perform the same work, the same responsibilities under similar working conditions, the same amount.
Where
And
in the statute would we find that command?
It's at the beginning of the statute where employers are prohibited from discriminating between employees on the basis of sex by paying wages to employees less than the rate at which he pays employees of the opposite sex for equal work, which require equal skill, effort, and responsibility performed.
And with respect to the affirmative defense and your claimed responsibility of employers to ensure that the prior pay isn't based on discrimination, where do you derive that? Because prior employer is not the employer.
We derive that from coupled with the case law and the EEOC guidance as to their recommendation that prior pay in isolation, because it perpetuates this type of gender discrimination, to consider other factors alongside the prior pay to bolster its credibility in justifying a wage disparity.
Would you say your approach is in a textual one, based more on the spirit of the legislation than the letter of the legislation?
Yes, Your Honor, but it also comes back to the textual requirement, that mandate, the statutory mandate of the Equal Pay Act. And Ms. Kadeb's prima facie claim is not something to be overlooked within this burden shifting framework as established by Corning Glass Works versus Brennan in 1974.
Let me ask this question. There can be a differential based on any other factor other than sex. We're looking for neutral reasons for a differential in pay. I'm just trying to understand, how does your standard fit within the facially neutral reasons?
It fits within it because of the prima facie claim that has been established by Ms. Kadeb. When we look to the record as to the pay disparity for performing the same exact duties, Ms. Kadeb was even confined to the same exact Hawaiian villa as the men in the show, finding romantic connections, building friendships, competing in challenges. There was no difference in the work done. And so when the employer, Love Island, decided to import and blindly import this pay disparity, they did so and it created a $48,000 difference between Miss Kadeb and Mr. Henry Jones. But not only that, the other three contestants on the show all earned less than Miss Kadeb. So there is a $48,000 greater difference in between Henry Jones and those three other women.
Counsel, is it your position that all of the employees on Love Island should have been paid the exact same?
If there were other legitimate factors to be considered, such as social media following, marketability, or other brand deals that would enhance and justify this disparity, then it would be our position that they could justify it. But just using this prior pay in isolation without any due diligence on Love Island's end as to the nature of this prior pay being utilized is unlawful under the EPA. And furthermore, when Love Island chose to, the due diligence would be to consider those other legitimate factors. But if they would choose to import this pay,
they actually have done here.
To choose to import this pay policy, they could have had conversations with Ms. Kadeb surrounding her pay. Ms.
Kadeb did not know before at that time, so she wouldn't have said anything about her pay that would have given them an indication that it was gender-based discrimination.
Correct. But if that due diligence had been provided, then it could have gone to a jury to determine its credibility.
So if at the time, if Love Island had said, Ms. Kadeb, we're using your prior pay, we do that for everyone, was yours discriminatory? She would have said, I don't know, because she didn't have any of this discovery yet. Would that have been enough? They asked her, would that have been sufficient due diligence?
It's still in our position would go forward to a jury trial based on coupled with these other facts that are found in the investigation, but that could have allowed for a jury to determine the credibility and intention of Love Island and their usage of the pay.
That's my issue though. What due diligence avoids a jury trial? What due diligence, in your view, is sufficient to say we can rely on this prior pay? We have convinced ourselves that this was fair. This other company's pay structure, we have done enough due diligence that we believe it was not discriminatory.
Any due diligence in with the previous employer as well to further bolster?
They're also going to say it's not discriminatory. They are saying that, right? So what does it actually look like? Can an employer ever satisfy the standard that you are proposing?
You can answer the question.
While it may be difficult for an employer to obtain definitive information as to the non-discriminatory nature of the prior pay, that does not mean that this should not move forward to a jury trial on these issues. And it's for those foregoing reasons that we respectfully request that this court reverse the 14th Circuit's decision. Thank you.
Thank you.
May I proceed?
Okay.
Good morning, Mr. Chief Justice, honorable justices, and may it please the court. My name is Carla Rubio, and I am appearing on behalf of the petitioner, Ms. Alaya Kadeb. The National Labor Relations Board's primary purpose is to protect workers from unfair labor practices. When an employer commits an unfair labor practice, as here, the National Labor Relations Act grants the board broad discretion to issue remedies necessary to restore an injured employee to their status quo ante, to make them whole. Anything less fails the Act's core policies. Today, we come before you because the 14th Circuit has erroneously found that the board exceeded their broad authority in awarding Ms. Kadeb remedies designed to make her whole. Instead, we request that this court reverse the 14th Circuit's fundamental misinterpretation of Section 10C for 3 reasons.
The lower court didn't disturb the contractual payment amount, right? That was ordered.
No, that was part of the order.
And I take it you're satisfied with that part of it.
Yes, Your Honor.
So we're really talking about reputational issues and lost business opportunities. Is that a fair assessment?
Your Honor, the remedies in question today are the wardrobe expenses and the brand deals, which I can take in part. The wardrobe expenses are employment induced and tied directly to the employment.
Was there a contractual requirement that your client buy wardrobe?
No, Your Honor, but as seen on page 4 of the record, the producers strongly encouraged Ms. Kadeb to buy this wardrobe. This was not $15,000 spent on a whim or on an impulsive shopping spree, but instead spent in reliance on the producers' conversation with Ms. Kadeb. Ms. Kadeb needed this wardrobe in order to perform the essential functions of her role as an employee, as a contestant on season 8 of Love Island.
And how would making that award serve the legislative goal that you were talking about earlier, which is to ensure that companies like Love Island Productions don't engage in this behavior going? What's the point of that?
Well, Your Honor, the purpose of the National Labor Relations Board is to restore injured employees to their status quo ante, to make them whole. This is part
I thought the purpose of the National Labor Relations Board was to prevent
unfair labor practices.
To protect workers from unfair labor practices. You are correct, Your Honor. But part of that is to mitigate and eliminate the effects of these unfair labor practices. And as seen here, Ms. Kadeb suffered numerous effects due to the respondent's unfair labor practice, starting with the no pay discussion clause and ending with the unfair
Could Ms. Kadeb
early
bring a
termination.
lawsuit for, unfair termination or something like that?
Well, Your Honor, there is no evidence in the record that shows to a lawsuit. What there is evidence of is the direct...
Is that a remedy that's available? In other words, do we have to build this into the NLRB's panoply of remedies available in order to see to it that justice gets done? Couldn't she have a different remedy available to her in another forum?
Your Honor, there is no need to import any language into Section 10C of the National Labor Relations Act because of its broad and expansive language, which this court has continuously affirmed. We can look at the operative word, including within the text. The text reads, and Congress empowered the board to take affirmative action, including reinstatement with or without back pay, as will effectuate the policies of the subchapter.
That's my problem, counsel. It's limited to back pay, reinstatement and back pay. I actually think the 14th Circuit got it right. On page 9 of the record, it said 10C authorizes targeted equitable measures such as reinstatement, back pay, cessation of unlawful practices, but withholds the power to award consequential damages, restructured substantive economic terms, or impose preventative mandates disconnected from the conduct at issue. Why isn't that the right standard that we should be looking at this by and that we should adopt?
Your Honor, the text of Section 10C does not say limited to reinstatement with or without back pay. It says including reinstatement with or without back pay. Reinstatement and back pay cannot be the outer limits of what an employee may recover.
Why not?
Because of the expansive language and the broad discretion that this court has awarded the board due to their over 90 years of cumulative experience and expertise in this one specific claim.
But this seems to go into policy making. If we allow those other types of damages, and I don't know exactly what word you'd use to classify them, but they could be viewed as being exemplary damages, maybe even viewed as punitive damages, which is, to my way of thinking, a policy decision. And I don't see anywhere that sort of policy making authority was given to the NLRB.
Your Honor, we can look to this court's precedent in order to draw the boundaries of what the board can and cannot award. In the case of Consolidated Edison, for example, the court found that when the board ordered an employer to pay the U.S. Treasury, that was considered punitive and beyond the board's authority.
Can you explain to me, counsel, how something like a handbag allowance or a clothing allowance, how is that remedial and not punitive in nature, especially where I'm assuming that the petitioner, in fact, can still use the clothing and handbags, whether or not she was on the show?
Or
correct?
sell it.
Or sell it and again, mitigate some of these losses.
Well, Your Honor, we can look to Ms. Kadeb suffered many damages in this case, but the board did not award all of the damages that she suffered. In fact, the board made a good faith effort at drawing the line at quantifiable, identifiable, and non-speculative financial harms that derived from Love Island. Ms. Kadeb suffered damages including the social media posts, the handbags, the brand trip with Vogue Beauty, but some of these damages were not awarded. In fact, the board made an almost surgical analysis looking at the damages and deciding what derived from the unfair labor practice.
Surgical implies that they were discerning about what damages to give and which not to give, but I feel like in this case, they came close to giving almost everything that they could possibly think. Where did they hold back?
they held back at damages that were more speculative in nature,
such as
whether or not Ms. Kadeb would even post something on social media worth that amount, or whether she would go on a brand trip.
So they didn't give her compensation that reflects a complete career collapse.
Correct.
They
Your
just
Honor.
gave her a severe career diminishment.
Correct, Your Honor. And that is because in the special nature of the entertainment industry, traditional back pay is no longer enough to be able to recover an influencer's name, likeness, and
Sorry, apologize, Scott. Isn't it correct that the petitioner in fact gained $3,000 a month in TikTok revenue?
That is correct, Your Honor.
Did was that subtracted from the damages awarded here?
Yes, Your Honor. We can see on pages 5 and 6 of the record that there was a hearing held with factual findings and competent substantial evidence to prove that the remedies awarded here were directly tied to her employment with Love Island. And that is why the board did this surgical analysis, because of their cumulative expertise and experience as a
Counsel,
decision-making body.
What I just heard you say before Justice Johnson's very sage question, that the NLRA is inadequate to meet the needs of a social influencer or perhaps other occupations that exist now that didn't exist when the NLRA was adopted by Congress. That's not our job. That's Congress's job. Why isn't this something that Congress should be handling? If they want to allow compensatory damages of the type that you're suggesting or punitive damages, that's their prerogative, not ours. Correct?
I understand your concern, Your Honor. It is not our position that the text of the language is faulty. In fact, the text of Section 10C is broadly phrased for the purposes of administrative application. As this court stated in Phelps Dodge and Frank Gross Co., it was meant to be broadly phrased because Congress cannot possibly provide an exhaustive list or a rigid scheme of every single form.
Specifically allow for compensatory damages, and it chose not to. You're trying to read a compensatory damages allowance into a statute that talks about back pay and reinstatement. While that may be in the frame of equitable relief, the statute doesn't even say equitable relief. It just says back pay and reinstatement. Why shouldn't we be limited to that until Congress makes a decision to do something different?
Because, Your Honor, the statute does not limit to solely equitable remedies. In fact, the only limit the statute provides is the broad and vague limit that the board must effectuate the policies of the act.
No. But you just heard the question from Justice DeLuca. What it talks about is reinstatement and back pay. There are specific types of awards that are listed in the statute. It just seems that they're not as broad as the ones that you'd like it to include. Where's that coming from?
I'm sorry. Go ahead. Answer.
The word including is illustrative. It is expansion, but not contractive, because it is meant to not cabin the remedies to only reinstatement and back pay, but to provide examples.
So you're simply saying that including creates a non-exhaustive list of remedial options.
Correct, Your Honor. Correct, Your Honor.
What if punitive damages? Oh, I'm sorry, Judge.
That's okay. But this is I'm looking at the language of the statute, which judges tend to do in fulfilling our responsibility. But it says the NLRB to take such affirmative action, including reinstatement of employees with or without back pay, as will effectuate the policies of this act. I mean, you can't get language more broader than that. Obviously, reinstatement and back pay is mentioned in the statute, but I'm just wondering, how do we interpret policies of this act? What are the policies?
Well, Your Honor, Section 1 of the National Labor Relations Act details the policies of the act, which are to promote peaceful settlement, to prevent unfair labor practices, and to protect employee rights, which in this case, the board is meant to eliminate the effects of unfair labor practices, which is exactly what Ms. Kadeb suffered here. And if this court finds that rather than these remedies being tantamount to back pay, that these are compensatory damages, this court held in International Union v. Russell that compensatory damages can be incidental to effectuating the policies of the act.
Where do you cross the line from compensatory damages to punitive damages? Because I don't think they mean punitive damages.
Well, Your Honor, it also has to do with the amount spent as well as the examples that were given in past cases. Ms. Kadeb or Love Island is not supposed to pay the U.S. Treasury. They're not supposed to shut down the show. They're simply supposed to restore her to her rightful position had it not been for the unfair labor practice. This is not punitive or arbitrary or inconsistent with the policies of the Act.
The statute doesn't say cure her economic harms. It just says affirmative action to effectuate the policies. Very broad.
Yes, Your Honor, we agree that it is broad language, but the broad language that has been construed by the board who has been vested with the power to interpret their statute.
If we disagree with you about the legislative purpose of the statute, if we think it's more about preventing unfair labor practices from taking place as opposed to compensating the victims of unfair labor practices, do you lose?
Can you repeat the question, Your Honor?
If we disagree with you about what the purpose of the legislation is, and we don't think it has anything to do with compensating people for the results of unfair labor practices, do you lose?
No, Your Honor, we do not lose here, because if you construe the statute at its base is about effectuating the policies.
But I think you might be avoiding my question. If our view of the statute is that its intent is to prevent the happening of unfair labor practices, which may have nothing to do with compensating the victims and more to do with modifying the behavior of the employers, how do you justify your argument for all these damages?
Your Honor, even if the statute is only to prevent unfair labor practices, if you affirm the 14th Circuit's finding, you will be immunizing employers from having to pay for their illegal actions. Here, Love Island unlawfully retaliated against Ms. Kadeb, firing her after her. I see my time is up, man.
Please finish.
Love Island unlawfully retaliated against Ms. Kadeb, and now Ms. Kadeb would have to bear the burden of the unlawful actions of her employer. And that is not the case here, Your Honor. At best, this would, affirming the 14th Circuit's decision, would deter employees from organizing against their employers, but at worst would chill the rights that the employees are meant to have under the Act and would eviscerate the peace that the Act intends to promote. Thank you.
May I proceed?
Please.
Mr. Chief Justice, and may it please the court. My name is Michaela Havison with co-counsel Ellis Nocky, and we represent the respondent, Love Island LLC. I will be discussing the 2 Equal Pay Act issues, and my co-counsel will be discussing the National Labor Relations Board issue. Today, we request that this court affirm the 14th Circuit's decision, and in doing so, request that for the first Equal Pay Act issue, the court maintains the evidentiary burden on employers. Second, for the second issue, find that the prior pay is a factor other than sex. Turning to the first issue, this court should maintain the 14th Circuit's evidentiary burden, which is either adjudication or a similarly robust internal investigation. And that is supported by 2 reasons. The first reason is the burden shifting structure laid out by the Equal Pay Act and as interpreted by this court. And the second is the 14th Circuit standard will defer misdirected lawsuits to the proper defendants. The 14th Circuit was correct for spending little time on this issue. One of the only cases to wrestle with the issue was Urban versus United States, and there they decided to leave defendants with a broad defense unless the plaintiff can bring highly credible evidence. The burden shifting structure, as extracted by this court from the Equal Pay Act and Corning-Goss versus Brennan, is first the plaintiff must make a prima facie showing they were paid less for equal work. And then the second step allows the defendant to raise one of 4 affirmative defenses.
Counsel, if the affirmative defense is, in this case, infected with sex discrimination, doesn't that eliminate your ability to rely on, in this case, the prior pay. If the prior pay was infected with sex discrimination, you lose, don't you?
No, Your Honor. At the stage of summary judgment, the petitioner needs to be able to show an issue of material fact, and there is not an issue of material fact in this
And that's
case.
because there was no prior adjudication, or and I think there was one other thing you said, an investigation.
The internal investigation supports the respondent's decisions based on the conclusions of it. The text messages, while
It does, but it also the investigation itself was a response to an allegation. So unless you're advocating for a rule that says we must accept the results of the investigation as its own extrajudicial fact finding, to me that's still a very open question.
No, Your Honor, that's not what's being asked for. The material issue of fact suggested by the petitioner has to deal with the wrong interpretation of the Equal Pay Act. The Equal Pay Act is not a disparate impact statute. It is a disparate treatment statute. And the evidence presented does not show disparate treatment by the defendant here today.
I don't know about that. Okay.
When you say there's no disparate treatment here, how do you explain, for example, the text messages discussing her weight gain and body? I guess I would ask you, how is discussing a female employee's body in pay negotiations anything other than sex-based discrimination, disparate treatment discrimination, in fact?
Your Honor, to be clear, those text messages and the emails were sent on Love is Death. The respondent is Love Island. While Love is Death may or may not have engaged in discriminatory practices, that is not the responsibility of Love Island. They couldn't have possibly known. Love is Death and Love Island have no relationship with one another.
But isn't that your I'm sorry.
No, go ahead.
Didn't your adversary make the point that that's precisely why you shouldn't have relied on just this one criteria, and that if this is constraining, walked into that and chosen that for yourselves, or your client has, because you could have looked at any number of factors?
Your Honor, prior pay includes a number of factors already. Prior pay, while it was the sole consideration in this case, combines many things. For example, the marketability of an employee on a reality TV show, their popularity, as it would pertain.
Why do you get to rely on that? You're disclaiming that in the policy. You're saying we are not looking at any of those things. And so you rely on a discriminatory prior pay scheme. And then you also want to take shelter in saying, well, I'm sure even if it was a little bit discriminatory, they relied on other things. Why is that fair?
Your Honor, as the chain of employers grows, disparate treatment turns into disparate impact over time. And that draws to the point about why prior pay is a factor other than sex, and that's based on the text of the Equal Pay Act. When read on its own, the catch-all factor clearly reads, except any other factor other than sex. The statute says—
Counsel, even the Fourth and Seventh Circuits require factors to be bona fide. So how is refusing to consider anything else bona fide decision-making?
Your Honor, it is bona fide decision-making because according to the first page of the record, Love Island did investigate other pay policies and found this to be the most equitable option available.
What's the basis for that?
Your Honor, the basis for that is simply stated in the record that they looked at other options. But what the petitioner assumes is that under a different pay model, Ms. Kadeb would have paid more. On page 5 of the record, it suggested that her popularity—
Well, she may assume that, and she may be wrong. She may have ended up getting paid less if you looked at other factors that she didn't square eye on. But the larger question here is, what justifies the decision to base your entire compensation structure on past employment? And if I could just add some color to that question, if you look at the broad policy reason behind the act, it's to remedy past invidious employment practices, one of which is paying members of certain groups less. So to me, the idea of using past pay is almost remarkably obtuse. But I must be wrong, so tell me why I'm wrong.
Your Honor, this is reflected in some of the recent congressional history. Between the years of 1997 and recently in March of 2025, there was amendments proposed for fair for a fair pay amendment that was proposed 15 times, and Congress rejected it every time. And that would have turned the Equal Pay Act into a disparate impact in addition to a disparate treatment statute, which would have foreclosed the ability of prior pay. But Congress rejected that.
Did they actually vote? Did they actually vote to not adopt it, or did it just not even come up for a vote?
Your
To be
Honor,
clear.
3 times it came up for a vote, and all 3 of those times it was rejected. So Congress had the opportunity before them to make that change. And here Congress decided not to do it because they didn't want to cripple a legitimate business practice.
But it seems to me that if an employer wants to be reliant on market factors, which is what prior pay allegedly is, and that prior pay is infected with sex discrimination, as the petitioner has suggested the prior pay was here, that's the risk that you took, your client took rather, and now why you should perhaps face a jury to see if your client calculated incorrectly.
Your Honor, the other affirmative defenses provided can give an answer to this question. Those affirmative defenses are merit, seniority, and production-based factors. This question suggests that none of these factors have anything to do with sex at all. However, it's a widely known fact that with seniority, men are often able to stay at companies longer because of different responsibilities in society. Additionally, with merit, there's the chance that men are viewed as more meritorious in our system of work. And then with production-based factors, there may be more accommodations for them. The Seventh Circuit in the case Riordan versus Campiner says, quote, seniority can easily propel a subordinate worker into a higher pay classification than his superior.
But really, aren't the 3 factors before the 4th one, they're really based on collective bargaining agreements and employment agreements. That's not really going to shed a lot of light on factors other than sex. So I still think that when you have an employment decision that is based on admittedly a prior employer's decision that was infected with sex discrimination, your client is in essence adopting that discrimination as its own motive, perhaps.
Your Honor, the text of the statute says any other factor than sex. Additionally, it's important to note that the catch-all factor was added as an amendment to the enumerated factors because of what this court described in Corning Glass and as in Washington County versus Gunther as, quote, concern that a bona fide job evaluation system used by American businesses would otherwise be disrupted. Prior pay is frequently relied on, and it is a legitimate business practice, which may be why employees often use it in negotiating their new salaries.
This question, since you set salary strictly based upon prior pay, and it came up in the case on summary judgment, an investigation was done by the prior company. The employer hired investigators to determine whether or not their pay structure was discriminatory. For summary judgment purposes, why should a plaintiff be bound by an employer's investigation of itself where they're exonerated?
Your Honor, to answer that question draws again between the distinction between Love is Death and Love Island. The evidence provided at summary judgment doesn't question the actions of Love Island itself. They applied an objective, robotic, mechanical application of a pay policy to every single contestant that was on that show. Additionally, some of the facts that were neglected in the summary judgment discussion include the fact that on Love is Death, one of the male employees was paid less than some of the female employees. So that undermines that claim there. Additionally, Love Island's practice is legitimate because of the way that it connects to the industry standards. This court in Corning Glass versus Brennan viewed the case through the standards of the manufacturing industry. And there they decided that time of day was a pretext given the industry. But looking specifically of Love Island and the reality TV industry, reality TV itself is a highly speculative industry. Oftentimes, producers won't know how much a show will make until it airs that day. And because of that, it adds a challenge for employers and employees to come to fair pay agreements.
Counsel, isn't that even more of a reason to consider more updated information like marketability and social media following rather than a prior pay that may have been set at a time that is no longer relevant to the current situation?
Your Honor, prior pay incorporates those things that you just said, while also ensuring that
Counsel, didn't your client's policy expressly exclude any other factor other than prior pay? That would exclude marketability. That would exclude social media following, right? Isn't that correct?
Yes, Your Honor, but Love is Death did consider those things, and other reality television shows do as well.
So you're saying your client relied on Love is Death's assumed consideration of other factors and then adopted them with a 20% increment attached to it. Is that really what happened?
Yes, Your Honor, but with the 120% raise, that was applied across the different contestants on the show. And additionally, a key...
No, but it's the earlier part that interests me, that this implicit assumption that all those factors that you just heard listed, marketability, popularity, all the things that might increase a person like this's salary, you just assume that they were considered by the prior employer.
Your Honor, it's not an assumption that it was considered by the prior employer, but rather trying to get an assessment of what an employee's market value is coming to the show of Love Island. They needed to be able to understand how much she had been previously paid in order to ensure that they were paying her a fair amount. And again,
Wasn't that number set years before the Love Island set its pay scale for this particular season?
yes, Your Honor, and that's an even more compelling reason to use the 120% prior pay model. And that's because, as previously stated, they did look at other options and decided that this was the most equitable. An implication of that is that Ms. Kadeb would have been making less because her popularity had declined over time.
Counsel, are you saying, so I'm clear, that your client considered other factors when deciding Ms. Kadeb's salary?
Your Honor, there are no details in the record specifically of those pay options that were looked at, but the assumption behind that is that it would have had to have been another option other than prior pay.
But not with respect to Ms. Kadeb or any other specific individual. So you're saying that they considered those options, then settled on this policy. Is that what you're saying?
Yes, Your Honor.
Okay, thank you. I appreciate your clarity.
Additionally,
I'd like to turn to something else for a second. I've been thinking a lot about Rizzo versus Jovino, and I'd like to hear why you think that is not the decision that we should be adopting here today.
yes, Your Honor, Rizzo versus Jovino discusses the fact that some of these affirmative defenses seem to be job-related. However, as previously stated, other circuits' decisions support the fact that these aren't actually job-related, and that's a bold assumption. For example, as stated earlier, the Riordan versus Competer case said that seniority can compel a subordinate worker into a higher pay classification system than his superior. So the job-relatedness connection, the attempt to invoke adjustum generis in order to explain this discrepancy just doesn't sit quite right with the text of the statute. And for the foregoing reasons, we ask that this court affirm the 14th Circuit's decision and require plaintiffs to show credible evidence for the proper defendant.
Thank you, Counsel.
Mr. Chief Justice, and may it please the court. My name is Ella Snocki, and alongside my co-counsel, Michaela Havison, we represent the respondent, Love Island LLC, and urge this court to affirm the holding in the 14th Circuit that the NLRB overreached their statutory remedial authority in awarding expanded compensatory damages retroactive to the inception of employers' unlawful pay policy. Your Honors, this is a case about protecting the separation of powers by upholding Congress's intent evidenced within the plain language of the statute.
You say retroactive, I take that to mean you take issue with the fact that the damages weren't calculated from the time that the complaint was filed forward. Is that right, or is there more to it than that?
Yes, Your Honor. In addition to that fact, respondent also takes issue with the fact that, particularly with the wardrobe expenses, those expenses were incurred prior to even employer's unlawful termination of Ms. Kadeb. So it goes beyond mere retroactivity, which, As back pay is enumerated within the statute, some degree of retroactivity and looking backwards is fair within this case.
So what would you call those damages? Are they compensatory to you, or do you put a different label?
The damages, as in the consequential damages?
The wardrobe, all the things that you said may have been ordered either before the termination or even before the filing of a complaint. What types of damages are those? Since we seem to be putting labels on things.
Yes, Your Honor. The damages at issue in this case are both consequential and in some cases even punitive. As was given by this court in the recent decision in SEC versus Jarkissi, a civil penalty is wherever, even when a remedy does have some remedial qualities to it or equitable qualities to it, if it cannot solely be explained from a remedial perspective, if it implicates any sort of a deterrent motive.
Can I take a try at explaining the wardrobe? She was encouraged. I believe the record supports her allegation, or at least gives her cause to allege that she was encouraged to go out and purchase wardrobe for this production, which she duly complied with. So now we're simply putting her back into to get her to her status quo ante once it's determined that there was wrongful activity that took place. What's wrong with that?
Your Honor, because allowing the award of the wardrobe expenses actually does not restore the status quo ante. Ms. Kadeb was never promised reimbursement of those wardrobe expenses, and therefore, even in the status quo, where the employer did not engage in an unfair labor practice, Ms. Kadeb never would have been reimbursed for those anyway. Further, the employer merely encouraged, and as the record states, did not require the purchasing of these wardrobe expenses. Therefore, petitioner's advocacy actually puts Ms. Kadeb in a position beyond the status quo ante because she was never guaranteed reimbursement. That is where these damages cross into punitive territory because they cannot be explained purely from a remedial perspective.
So if the contract that was being dangled in front of her included buy your own clothes, do your own hair, bring your own makeup team, and by the way, you have to provide yourself with transportation to and from the production site. All that would be completely non-compensable under your view of what types of remedies are allowed under this act. Is that right?
Not necessarily, Your Honor. Respondent adopts the approach of hiring management from the Fifth Circuit, which talks about the umbrella of back pay. So where certain benefits are guaranteed by a contract, respondent believes that those count under the traditional umbrella of back pay and therefore qualify as a make-whole remedy. However, the problem is these consequential damages that Ms. Kadeb requests in this case fall outside of the umbrella of back pay.
Well, it seems to me you're narrowing the language of the statute by just relying upon a contract. And some of the other things you said, the statute said that the NLRB shall take such affirmative action, including reinstatement of employees with or without back pay, as will effectuate the policies of the Act. Affirmative action could even include, to some extent, some punitive action. No?
No, Your Honor. The term to take such affirmative action has historically been interpreted by this court in an equitable sense. As was the case in Consolidated Edison Co. versus NLRB, this court characterized the power of the NLRB in a remedial sense.
Well, why can't we just define what she's seeking as economic harms and get away from any other language and just award her for all the out-of-pocket expenses she had or the loss of employment opportunities, and the NLRB has the authority to do that under the statute.
Because, Your Honor, economic harms do not fall under the umbrella of equitable remedies that this court has historically allowed under the NLRB. This is reflected in the fact that this court in Republic Steel Corp versus NLRB explicitly stated that the NLRB does not have punitive power. It also furthered in UAW-CIO versus Russell that a suit under the NLRB is a mere, quote, partial alternative to a suit in the state court for a loss of earnings. Your Honor, the NLRB was never meant to be an all-encompassing, all-serving, make whole in a legal...
You're suggesting that Ms. Kadeb would have a cause of action under, I guess in this case, perhaps California state law, for whatever other relief that she would want to seek in this situation. But what's the basis of that cause of action here?
Yes, Your Honor. Respondent would suggest that if Ms. Kadeb believes she has a legitimate claim, she should sue for a breach of contract with these third parties. Your Honors, it is important to remember that the consequential damages at issue in this case stem entirely from third-party relationships that do not have anything to do with the contractual relationship between my client.
Respectfully, counsel, it extends from your client's unfair labor practices in having an unlawful no paycheck discussion rule and in terminating Ms. Kadeb and her colleagues after they violated that rule. So retaliatory termination. So really, this is a situation where under the National Labor Relations Act itself, consequential damages do seem to be warranted. And that's exactly the type of relief that she's seeking here.
Yet, Your Honor, even the National Labor Relations Board themselves do not see consequential damages as falling within their traditional make-whole remedy. As on November 10th, 2021...
Can you attach a different label to it? Can you say it's remedial? What makes those types of damages, the ones that were awarded here, not remedial?
Yes, Your Honor, because...
Remedy? It's clearly a remedy.
Yes, Your Honor, because they cannot be explained purely in remedial terms, particularly with the wardrobe expenses, those were not going to be restored to her in the status quo. So the only way to really explain why she's now being compensated for them is because the NLRB says, employer, you did something wrong. You now deserve to pay for this, even though you weren't going to have to pay for it otherwise.
That sounds very punitive. But what about, and obviously that's why you did it that way, but what about saying, you know what, this woman is out of pocket, $15,000 on clothes, and now it turns out that she was the victim of a unfair labor practice. She should have her $15,000 back. That sounds like a remedy to me. You're making her whole. What's wrong with that?
Because, Your Honor, efficiency within the court system should not come at the expense of due process. And ultimately, this claim should be heard in an article.
Did she not have a hearing? I mean, weren't her views and the company's views hashed out in front of the ALJ and at the NLRB?
Yes, Your Honor, she did have a hearing. However, only Article 3 courts have the ability to award legal remedies. And these are clearly legal remedies stemming from a legal cause of action. Ultimately, the basis of Ms. Kadeb's claim that results in these consequential damages stems from tort. It stems from tortious interference that Ms. Kadeb alleges that Love Island engaged in. That should be adjudicated within an Article 3 court in order to protect due process.
Sounds like a state claim, so I'm not sure it's an Article 3 court, but okay.
Yes, Your Honor. Even if it were to be in a state court, as was discussed in UAW-CIO versus Russell, the NLRB was never meant to be a full alternative to a claim in a state court.
Sounds awfully inefficient.
Let me ask, the NLRB has adopted an expanded conception of make-whole relief, awarding compensation for a broader range of economic harms and applying relief retroactively. It seems to me that you're challenging directly the discretion that the NLRB is given under the statute.
Yes, Your Honor. First, in a post-Loper-Bright Enterprises v. Raimondo world, this court must still engage in its own independent statutory interpretation. And even if we did owe deference to the NLRB's interpretation, I would like to turn back to this piece of evidence from November 10th of 2021, where the NLRB asked the public for briefing on this issue and asked whether they should, quote, expand their traditional make-whole remedy to include consequential damages. Your Honors, this is clear evidence that even the NLRB themselves do not believe that consequential damages are within the traditional make-whole remedy.
Wait. The board asking for comment on something is your contention now is that they didn't think that they had the power to do it?
Yes, Your Honor.
And yet they did it and thrive, correct?
Yes, Your Honor.
So they actually do think that they have the power to do it. And you've suggested today that the board has not taken the position that it has the power to issue consequential damages, and yet they've done it and thrive, and they did it in this case as well. So clearly the board thinks that it has the power to do that.
Now, Your Honor, yes.
Okay, so before the board in 2021, they may not have considered it. You don't have any evidence to say that they previously considered it and rejected that idea, do you?
Yes, I do. Indeed, in the case Meyer-Toole, the NLRB specifically said that General Counsel had requested consequential damages. However, that fell outside of their traditional remedial authority, and therefore they were not going to award consequential damages.
Would you say, though, that this falls into the relief in this case falls into the type of what I think this court and Franks Brothers called the capacious relief that the National Labor Relations Act has empowered the board to provide to people like Ms. Kadeb? Why is that not the case?
Your Honor, because capacious relief does not necessarily mean all possible consequences of the unfair labor practice are implicated. Looking back to the plain language of the statute, Section 10C specifically talks about taking affirmative action. That is an inherently equitable phrase because it gets at the key to equity, which is to either compel action or to compel inaction.
Counsel, do you see and the lost brand deals that we should be?
Yes, Your Honor. To a certain extent, there is a distinction here, yet the lost brand deals also fall outside of the statutory authority of the NLRB because they follow a very attenuated causal chain of events that ultimately are not limited by any foreseeable or direct claims that petitioner may rely on, as that was the standard established in Thrive. Ultimately, the record on page 3 details that immediately following the termination, the brand deals were not immediately resized. Ultimately, Ms. Kadeb herself made a TikTok video and posted it discussing the issue. And then the record states those brand deals became strained and ultimately those third parties decided to breach their contracts. So the causal chain of events is not entirely clear. And as that causal chain gets cloudier and cloudier, these damages look more and more like civil penalties, as was established under SEC versus Jarkin.
Was there proof in the record at the board level to suggest these facts? Because I know that that's in the record, but I don't know that that was actually shown in the board proceeding. Did your client show that in the board proceeding?
That Ms. Kadeb had made it.
Her other conduct. Did your client argue in the board proceeding that her damages in this case were affected by her post-termination conduct?
Your Honor, there's not evidence in the record discussing what my client brought up at the lower court in relation to Ms. Kadeb's conduct.
So it would be difficult for you to argue that right now if we can't say for certain that you raised that argument before.
Ultimately, Your Honor, the focus is on how allowing such an attenuated causal chain of events or speculation on how many social media posts Ms. Kadeb may have made would unfairly implicate my client. This is not the proper... Your Honor, may I briefly? Okay. For the foregoing reasons, respondent urges this court affirm the 14th Circuit. Thank you.
I don't.
Justice Speight posed the question to respondent. They attempt to take shelter in the action of a previous employer. The choice for respondent to take shelter in this previous employer is telling. To blindly adopt a pay structure, as Justice DeLuca noted, infected with sex discrimination, demonstrates the problem of using prior pay in isolation and permits employers to ignore the promise of the EPA to pay individuals the same wages for the same work. This prevents female employees from ever unburdening themselves from layers upon layers, years after years of sex discrimination within the workplace, and does not allow the promise of the EPA to ever be met, and leaves plaintiffs like Ms. Kadeb waiting for that promise to be met. and it is for the foregoing reasons that we respectfully request this court reverse the 14th Circuit's decision. Thank you.